Let's start first with what arbitration is not. Often arbitration is lumped into broader ADR categories, but it and litigation are determinative forms of dispute resolution, whereas many of the other forms of ADR that are often referred to are not determinative. They're simply facilitative. So what are those broader ADR categories? Negotiation. It's a form of resolution of dispute, but it only results in the parties reaching some form of agreement through discussion, not in an enforceable determination made by a third party. Similarly, in mediation, the presence of a third party facilitator, in this case the mediator, assists the parties in reaching a negotiated resolution of their dispute.
In today's new norm, so much is being done virtually and online. In terms of procedural hearings, having it virtual or by way of video conference or even by way of teleconference is a very, very common situation. And this is something that most parties would be used to. Because at the end of the day, this is like a planning type of meeting. Usually there's not heavy arguments, and certainly there are no witnesses. However, it is now increasingly common that even witness examination is done by way of video conference. In the past, it wasn't unheard of. It could be that, let's say, most witnesses are available in Jakarta, but you have one witness who is, for example, an expert, and he is based, to give an example, in Norway. And the parties agree that that witness will be giving his evidence by way of video conference.
Now, once the expert determination has been issued, what happens next? Well, since expert determinations arise from an agreement between the parties, they are normally binding as a matter of contract law. The winning party seeking to enforce a determination will therefore have to enforce it as they would any other contractual term. The bases on which expert determinations can be challenged vary between jurisdictions. However, there are three common grounds that seem to arise in many jurisdictions where my colleagues and I have practiced. The first is fraud. If the expert determination was obtained through fraud in some way, many jurisdictions won't enforce that determination. Secondly, if there is some manifest error in the expert determination itself, then that is also grounds for setting it aside in most jurisdictions.